I was just on a panel examining Justice Scalia's jurisprudence as it relates to national security, international law, foreign relations. There was some disagreement on the panel. I think two of us had clerked for Justice Scalia, so I think we were a little bit more sympathetic to his views, or at least we understood his views and principles a little more thoroughly, perhaps. The other two participants, in classic Federalist Society fashion, were a little bit more skeptical, so we had a healthy discussion, a healthy debate. You could view Justice Scalia's jurisprudence in the area of international law and foreign relations through the same lens that you judged almost all of his jurisprudence, with a focus on his commitment to textualism, the primacy of text in interpretation, originalism, focusing on the original public meaning of the enacted legal text, and separation of powers, which is created by the constitutional text and is consistent with the original meaning of the Constitution. His view was that the Constitution gives primary responsibility to Congress and the President to decide how to use international law, if at all, what decisions to make on matters of national security, particularly as it relates to foreign threats. Some people think the Constitution should apply to everyone, everywhere in the entire world at all times. Anytime the U.S. government takes action, people affected anywhere in the world have constitutional rights. Don't think that was Justice Scalia's view, and certainly not even the court's view, current view. Justice Scalia was a very consequential justice in all areas of law, and this is no exception. Reading his opinions, concurrences, dissents, majority opinions, always provides insight into how to think about these questions. Whether you agree with him or disagree with him, you always come away having learned something and know more than you did before, when you started.